Good morning. Today is Tuesday, July the 9th, and we are back for our Tuesday tip. For those of you new here, welcome. My name is Pia Miller. I'm an attorney in Virginia, and every Tuesday I come in and talk about a little something random. That little something random for this week. If you watched last week, you kind of got a highlight. So last week I talked about the 2024 family law legislative updates because again, all the new laws take effect, generally speaking, on July 1st. So it's July, let's talk about those new laws. This week we're going to talk about the criminal laws. So some of the new things that we have. Want to also highlight the fact and remind you guys, I kind of said it last week, but want to say it again. This year we had a record number of vetoes. So things that made it through bipartisan legislation, made it to the governor's desk for signature, and he said, I don't like this, and he decided to veto it. So I'm going to kind of go backwards and talk about some of the things that got vetoed because I do believe that they are bills that are maybe going to come up again over the next year or two. But these are also points where if you have a concern about these things that got vetoed, you need to be talking to your local elected officials, but then you also need to be advocating with the governor and, just making your voice heard. You voted, and if you didn't vote, you need to vote. Okay, first veto. Senate Bill 23. This bill would have established the minimum age of 11 for prosecution. Again, bipartisan bill, that got vetoed. Next one, Senate Bill 334. That would have eliminated Fourth Amendment waivers in plea agreements. Pia, what's a Fourth Amendment waiver? Why is that a big thing? So your Fourth Amendment right is your constitutional protection against illegal searches and seizures. So what you will see sometimes, and this is not necessarily statewide, it is very prosecutor specific, it is very office specific. You will see prosecutors put into their plea agreements that you have to waive your Fourth Amendment rights for X amount of time, or it might be the entire time that you're on probation, things of that nature, or the entire time that you have a suspended sentence. So that looks like in real life, what that looks like is you're stepping out of your house to go to Wawa, the local police, because they know you and it might be a small locality and they know that you've got this Fourth Amendment waiver as part of your plea agreement. They'll just come up to you and just say, hey, what do you have on you? What's in your car? What's going on? What's in your backpack? What's this? What's that? You can kind of maybe see why that's a problem. So again, some judges have made it clear that they don't like it and they will not authorize it in plea agreements. Some judges are perfectly fine. They don't read into it. Again, this is very locality specific, but it is something that happens quite frequently. And so that got vetoed. House Bill 803, that would have authorized juvenile felony expungements at the age of 29. Pia, I thought all juvenile felonies, I thought it automatically just all went away. No, it doesn't. That's a longer conversation. If you have questions about that, you need to talk to me. This is also why I tell everyone, like if you were convicted of a felony as a juvenile, that does not mean that once you turn 18, you can buy a gun or things of that nature, because you can't. You are barred. Having that felony conviction, you are barred from owning a firearm. If you have questions, you need to reach out. All right, House Bill 1515. That would have required prosecutors across the state to provide electronic discovery responses. Pia, I thought they were doing that. They have body camera footage and they just email it to y'all as defense attorneys. No, they don't. There are some states that refuse, or not states, there are some localities that refuse for whatever reason. It could be budgetary, it could be just personal decision at the elected official, the head CA, the head Commonwealth's attorney. If that office has decided not to purchase the software, and even then the software has tiers, so there's just certain levels of the software that allows for the police to share that electronic footage with the prosecutor's office only, but then the prosecutors have to then buy the next tier, which is to be able to share it externally with us as defense counsel. So that is a problem. We have certain jurisdictions across the state, and I understand that we have a lot of rural localities across the state, but we have localities that are saying, oh, well, we don't even have internet service, and so we just can't do anything, and you just have to keep coming in personally and trying to review it, and even then we still might not show it to you, blah, 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 blah. So that bill that would have required the Commonwealth's attorney's offices to provide electronic discovery was in fact vetoed. I think that's probably going to come back up because it is definitely an issue in the defense community, because there are so many inconsistencies across how we are able to get the information that we need in order to adequately defend you all, prepare our cases, things of that nature. Talk to your elected officials, and that includes your elected Commonwealth's attorney. All right. That's just some of the vetoes. Again, a lot of stuff got vetoed. Let's turn now to some of the stuff that actually passed, and so some of the new legislation. Let's talk about Senate Bill 16, which was the corresponding House bill was 78. So that prohibits the issuance of things like search warrants and subpoenas to certain electronic companies. So some of the apps that would keep track of your menstrual health data. What Virginia was seeing from other states who have criminalized abortion, they were issuing subpoenas to apps and saying, hey, we want to be able to track this person's menstrual cycle and see whether or not they perhaps had an abortion so that they could then go into prosecution of that particular individual. So what we have done here in Virginia is we have prohibited the issuance of that type of subpoena or search warrant so that a person's menstrual health data cannot be given out to those offices for potential prosecution. So that's great. Senate Bill 363 makes it a new Class 1 misdemeanor. So that's up to 12 months in jail and or a $2,500 fine for knowingly possessing any firearm, rifle, pistol, anything that can basically shoot ammunition. If that rifle, firearm, pistol, however you want to call it, has a serial number that has been removed, altered, or changed, etc. So this was coming up a lot with ghost guns. Where you had serial numbers. There's a federal statute, but Virginia did not previously have a state level statute. So a lot of those offenses were being charged at the federal level. It also makes it a Class 6 felony to knowingly sell or give that same type of firearm. If the serial number has been altered, changed, obliterated, things like that. We now have a felony for selling, distributing, and we have a misdemeanor for knowingly possessing. All right, flipping the page. There was a lot that happened this legislative session, y'all. House Bill 266. That clarifies what happens when the police do not comply with the parental notification requirement before the custodial interrogation of a child. So a few years ago, we enacted a code section that required the police to notify the parents of a child before they interrogated that child. Seems like something we should do. It was not, in fact, a requirement, and I had that come up a lot. A lot of parents would say, hey, weren't they supposed to call me first? No, legally they weren't, but now they are. And the weird piece in the statute from when this code section was enacted a few years ago was that there weren't any consequences outlined. So what we had been seeing was, well, the police didn't comply with the procedure, but what do we do with that statement that was obtained? So there were a lot of motions to suppress. And what we have with House Bill 266 is that now any statements that were obtained are inadmissible unless the prosecutor proves by a preponderance of the evidence that that statement was made knowingly, intelligently, and voluntarily. So there's going to be still a hearing. There's still going to be some clarification, but this is something that does require some accountability on the part of police in terms of following this procedure with parental notification. Last bill I'm going to talk about, House Bill 1496. This one is interesting. This one requires state and local law enforcement agencies to report a list of all surveillance technology that they have procured on an annual basis. Pia, what does that mean? What are we talking about? So things like license plate readers, drones, a lot of this electronic surveillance equipment that has been developed over the last few years that police departments and law enforcement agencies have been using in order to just basically figure out who people are and what they're doing and, oh, is there some sort of pattern going on? But like no one really knows what they have and no one really knows what these departments own. And so how they're tracking you and what they're tracking and how it's being used and all of these things. So now on an annual basis, they're going to have to report it to one of the state departments, and then that state department is going to have a master list of everything. Presumably that's going to be subject to FOIA disclosures. And so if you want to find out what your locality has, you can submit that FOIA request. That one's going to be interesting. So we're going to see how that plays out. But it should hopefully just provide some transparency with what your local law enforcement agency is doing. Again, these are like a handful of the bills and the vetoes just in the criminal justice arena alone. There are a ton more. We're already at, almost 10 minutes and I haven't highlighted like 1/5 of what has happened in the criminal justice arena this year. So I strongly suggest, if you are not already following your local elected senator and delegate, you need to be following them, because a lot of them have put up on their social media or in their respective newsletters a lot of the updated legislation from this past legislative session. And then a lot of them are also hosting town halls, so you can get that information directly from them. Whew, that was a lot, y'all. Okay, it's like 939 degrees outside. Please make sure that you're drinking your water. As always, if you have questions, don't hesitate to reach out. Come back next Tuesday for our next Tuesday tip. And in the meantime, take care of yourselves, and we'll see you back.